Katja, could I ask you, does your jurisdiction respect nuptial agreements from other countries?
Yeah, I think they try to, but it's not if it's really against Swiss civil code. Okay, that would be part that they would not accept. Like if there was some maintenance discussion in there, some maintenance agreement that is not according to Swiss law, they would not hold up in court. So it is really strongly advisable to get legal advice on this. If they're, if I have couples in mediation who are from UK, they had an nuptial agreement and they want to get divorced, and they have to get divorced in Switzerland because they live here. So they really have to be careful on what court will accept in this situation, a Swiss court. And on the other way around, it's if they go back to the UK and something's missing in this court decree, in this divorce decree, one of the spouses can go back to UK court, and UK court will not respect the Swiss court decree. So this is something that really needs attention, that you really need to check into and be sure that you have in the end the result that you wanted to. So I have had different cases cross-border like that, and we have tried to, put a balance in this. So we don't give something to Swiss court that they can just throw out, but to find a solution that, gives spouses or future ex-spouses the best possibility to get what they really planned to do.
Yeah. And Kath, how does the Scottish system view foreign prenups or postnups?
I think again it would depend. I think it would depend on what the agreement said, and again the circumstances into which it was entered into. One thing that I do a lot with clients who may have a choice of jurisdictions, just for example, recently I dealt with one where my client was South African and her intended was Scottish, but they thought they may live in South Africa at some point. They thought they might live in France at some point. And my advice to them was basically get mirror agreements. Go to a lawyer in France, go to a lawyer in South Africa, take my version and get them to create mirror versions of that. Because as far as I'm concerned, that's really the only surefire way of making sure that in any respective jurisdiction in which they might reside, that those agreements might be upheld. But obviously the caveat, I think, from this discussion is that it's not setting rock anywhere. So, but it's the best we can do.
Susan?
I concur with Cass. So what I would advise clients is that in an effort to bolster the likelihood that their premarital agreement will be enforced beyond its place of execution, that the couple includes a choice of law clause specifying the law to govern the validity and enforceability of their premarital agreement. So most American courts will enforce choice of law clauses as long as the couples choose the law of a jurisdiction with which they have a substantial relationship, and that the law is not contrary to a fundamental public policy of the foreign state. So for example, in California, we're a no-fault system. So if there is something in the agreement that is based upon fault, so if there's something that really just flies in the face of the foreign state would be California in my situation, then there would be a problem. But I've worked with cross-border cases, and what I really like is, as Kath mentioned, when you work together with a lawyer and if that's what the couple is thinking, we might live here, we might live there, having the agreement, looking at the agreement from the perspective, communicating and working collaboratively with an attorney in another jurisdiction. And that's when I have found that agreements really feel like they're most enforceable.
Yeah. And Francesca? You're on mute.
Yeah, I was looking for the button. So it really depends. If we're applying Italian law and to a marriage, an Italian court would not recognize a nuptial agreement that has provisions regarding maintenance or child support, or it would be really difficult to have that seen. It could, there is some case law of agreements that have been considered binding of the intention of the parties that were not really changing anything in the marital system. It was more of an agreement between two parties. An example was of a husband who had invested money in in the house of the wife, and the agreement was that he would only ask for the money in return in case of divorce. I think if that had been an agreement dealt by, reached by Italian citizen, it would probably not have been recognized. Instead, it was easier for the court to see this as an agreement that made some sense, and it was not really involving principles that are not negotiable for Italian law, and it wasn't seen, I think, as a real nuptial agreement in some way. So, as I said, you can have our courts apply different laws according to the EU regulation, but I haven't seen, and I don't think there is any real case law that has recognized nuptial agreements, even in these cases. I think it's very difficult, especially when it considers maintenance or child support.
So we're all familiar with the choice of law clauses, and I think we're all familiar with the concept of mirror agreements in other countries. But it seems to emphasize the importance always of taking cross-border legal advice if you're dealing with international clients who are likely to reside in other jurisdictions, or clients who are likely to buy assets in other jurisdictions. So are there any other comments you'd like to make before we close?
Thank you.
Right. Thank you everyone for joining us. Thank you for listening to us, and have a good evening, morning or afternoon, wherever you are.